I had a client that was being paid 38% less than what they were owed in workers' comp benefits. One form was the reason. I caught the problem, I fixed it, and in less than 2 months, we settled the case for $25,000 more than what they would have walked away with. Workers' comp is a no-fault system. What I mean is, you don't have to prove that your employer or boss did anything wrong to cause your injury in order to recover. Now, you can't sue your employer in regular court. Instead, you have to pursue benefits through the North Carolina Industrial Commission. That's the trade-off. Now, what does workers' comp pay? You get your medical treatment paid for. You get lost wages based upon 2/3 of your average weekly wage. And if you have a permanent disability, you get paid out for that based upon the body part that was injured. Typically, in the first 30 days of your injury, 5 pieces of paper are going to land in your lap. Most people don't know what they are. Here's the cheat sheet. The Form 18. That's the notice that you got hurt. Now you file this, and it's important that you file it within 2 years from your accident or your claim may be barred. Form 19. That's your employer's notice to the Industrial Commission of your accident. The Form 22. This is the form used to calculate your average weekly wage. We're going to come back to that in a minute. Form 60 or Form 61. This is filed by the insurance company that says they either accepted or denied your case. And a Form 25C, which provides authorization for the release of your medical records related to your injury. You don't need to memorize any of these numbers. You just need to know that it's likely that you're going to see these forms very soon after your accident. Now, I had a client that got hurt on a construction site, ended up suffering an injury to their finger. Now, the medical treatment was relatively straightforward, but it was the type of injury that took a while to heal, and as a result, they were out of work for many, many months. Now, within the first couple of weeks of the injury, the adjuster calculated my client's average weekly wage and started paying disability benefits. The checks that came in were for $775.01. Now, that's an oddly specific number. Hold on to it. In North Carolina, you're paid based upon 2/3 of your average weekly wage. So when I see a number like 775, I can back solve and calculate that the average weekly wage is roughly $1,160. But my client was a high earner. I knew that the average weekly wage should have been over $2,500, which, based upon what the insurance company was using, $1,160, that was over 50% difference. So I pulled the wage records and requested a Form 22, looked at the calculation, and sure enough, it was over $2,500 a week. And as a result, my client was entitled to the maximum compensation rate for his year of injury, which was $1,254, not $775. That difference of about $479 a week factored into the 5 months that my client had been out of work. It also rippled into the settlement math. And as a result, my client walked away with more than $25,000 than they would have before. So I'd been on the case for about 6 months, and I'd been pushing for this corrected Form 22. Once I finally got it, the case settled within 2 months. So not only did it put more money in my client's pocket, it also broke the logjam so we could get the case resolved. The carrier knew their numbers were wrong. They didn't want to litigate it, and instead they came to the table. Every weekly check, every settlement offer, every disability rating is calculated using that number. So you can either get it right at the start or spend a year trying to claw it back. There are 2 ways that the insurance company gets the average weekly wage wrong. They look like the same mistake, but they're not. They're both on the Form 22. Generally speaking, your average weekly wage is calculated by taking your earnings for the year prior to your accident and dividing that by 52. It sounds simple, but it isn't, because the adjuster will often leave things out. Things like overtime, bonuses, pay increases for shift differentials, commissions, per diems. What the adjuster may do is take your hourly rate, multiply that by 40 to arrive at your average weekly wage. But if you receive quarterly bonuses or pay increases for shift differentials, you've just been shortchanged every week that you've been paid. North Carolina caps how much workers' comp can pay you each week, and that number changes every year. So if your real average weekly wage 2/3 of that amount is more than the cap is what you get. Here's where high earners get burned. The adjuster arrives at an average weekly wage that's too low and then starts paying you based upon 2/3 of that low number. But they never go and check if your real average weekly wage is enough to entitle you to the cap for the year that you're injured. On my client's case, both errors happened at once. One was that the average weekly wage was way too low, but then the second was that 2/3 of that amount entitled my client to the max compensation rate for the year of their injury, which was $1,254, not $775. So when the adjuster faced the corrected math, they had no choice but to accept and pay my client at the maximum rate for that year. If you're a salaried earner or an hourly worker that often works overtime or has a shift differential, or you receive a commission and bonuses, there's a very high likelihood that your Form 22 could be incorrect. Don't accept the average weekly wage being offered to you by the adjuster before you have a chance to look at the math and also to confirm whether or not 2/3 of that number entitles you to the max rate for the year of your injury. If you got hurt on the job in North Carolina in the past 30 days or even the past 6 months and your case isn't closed, here's what you need to do this week. Number one, pull your pay stubs, all 52 weeks prior to your date of injury. Make sure bonuses are included too. 2, ask for a copy of your Form 22. The insurance company or employer is required to give it to you. Number 3, compare. Take your earnings during that 52-week period and divide by 52. That's your average weekly wage. Now take 2/3 of that amount and compare that to what you're currently being paid. 4, look up the state's max comp rate for the year of your injury, not the current year. And if 2/3 of your average weekly wage hits or exceeds that cap, you're entitled to the cap. Number 5, don't sign anything, not a return to work form, not a settlement offer, not some acknowledgement of what your average weekly wage really is until you read it with someone. If at any point the math doesn't match what you're being paid, that's your signal to stop and ask for help. That's the playbook. The Form 22 is the form that is critical to valuing your case, and often mistakes are made. In my case, a 38% gap between what was being paid and what was owed resulted in an increase in value of more than $25,000. And it also resulted in the case settling in less than 2 months. Oftentimes, injured workers never even look at their Form 22, much less check the math to make sure it's correct. That's a mistake. So, if you have a friend or family member dealing with a case, you'll be glad that you sent them this video. I'm Brad Smith with the law offices of Bradley H. Smith. I help injured workers navigate workers' comp cases every day. Talk to you next week.